Thank you, Kanika, and good evening to you all. I have been asked to speak on the evolving landscape of arbitration and IP litigation in India. When we talk of arbitration, some of the questions that are often asked in seminars, discussions, and catch our immediate attention are questions like, what is the role of courts in arbitration in India? Is there excessive intervention by courts in arbitration in India? How has the legislature evolved the Indian statute in terms of keeping pace with the requirements of arbitration and the industry? Is India an arbitration-friendly jurisdiction? Will India ever become an arbitration hub? In IP litigation, I would often be asked, what are the causes of delay in our system? Is India's IP jurisprudence keeping pace with the jurisprudence internationally? What is the quality of our judges? Things like that. I am not going to talk about any of those things tonight. I thought that I would take this opportunity to express my views on much smaller issues, smaller changes, which are significant, and I'm fairly certain that they will have a cascading effect in terms of both IP litigation, commercial litigation on one hand, and of course arbitration on the other in the next few years. These are more of nuts and bolts issues that I think we must consider for the purpose of understanding where our arbitration practice and commercial litigation practice is heading. The starting point, of course, and on which we can hardly have any dispute, is that there is a huge gap between international best practices in arbitration and commercial litigation and what we see here in India. Let me come to arbitration and discuss some of the very fundamental changes that I have observed in the last 2 to 4 years in the domestic arbitration regime. First of all, written advocacy. As many of you would know, that India is a jurisdiction where oral advocacy is overrated. We often used to hear about engaging counsel based on face value, who can pick up a point in 2 minutes and make a point in 2 minutes. All that doesn't work in commercial litigation and arbitration, because it requires great attention to detail and great focus on evidence, both documentary, oral, and any other materials. Advocacy in arbitration and commercial litigation is an entirely different skill set, and it cannot be entirely dependent on oral advocacy. When I started practice some 3 decades ago, in commercial arbitration, I would not be surprised when I would see oral submissions going on for 10 days, 15 days, where the arbitral tribunal was being taken through every bit of evidence on the file. That has changed in the last few years. There is a lot more appreciation of written advocacy by tribunals, and there is a lot more focus on written advocacy by counsel. It saves time. It allows you to reflect and process your thoughts and put very well thought through propositions before a tribunal. It allows you to then supplement your written submissions in a very short form in a limited time that is given to you for oral advocacy. Anybody who was to look at India's changing landscape in arbitration and then comment upon it over a period of 10 years or the last 10 years would tell you that one of the most significant developments in arbitration in India is to give written advocacy the due that it deserves or the importance that it deserves, which we of course have seen in international arbitration for a very long time. The next trend, which is also of great significance and is much more recent than that, than 4 or 5 years, perhaps I would say in the last 2 years, is the increased reliance on transcription services for the purpose of recording evidence in arbitrations in India. The result of not relying on transcription services was that cross-examination and recording of evidence used to take ages, and often it was of very poor quality, because the manner it was, I don't need to discuss that in too much of detail, but the manner in which it was done, there was no spontaneity in it. The reason why transcription services had not picked up in India is because despite being such a big country with tremendous resources available to us, nobody had invested in transcription services. Courts had not taken an initiative to rely upon transcription services, and to get transcription services from abroad for smaller domestic arbitrations didn't make commercial sense. What we have seen now in the last 2 years is that there is a lot of investment, innovation, and effort that is going into creating our own domestic transcription service providers. And I have immediately noticed that even in domestic arbitrations where transcription services are relied upon, the time spent in the evidentiary hearing is much smaller, is much shorter, and the time is used much more efficiently. And more importantly, the cross-examination then becomes one of the pivotal aspects based upon which arbitral tribunals make up their mind. The third, which I think is also a significant development, is the increase in the number of boutique-focused arbitration practices, whether in the form of law firms or in the form of 2 or 3 sole practitioners getting together and focusing only on arbitration work. The result of that is that we see a lot more professionals who are not dividing their time between court work and arbitration when it is only one of the two that they can really devote their time to. The advantage I wouldn't really say advantage, but the significant positive outcome of the development of smaller boutique practices which are focused on high value matters and are willing to give them the time and attention that they deserve is that I think that the quality of adjudication in commercial arbitration has gone up quite a lot. These 3, I think, are significant developments. There is a fourth development which of course exists, but I would want a lot more progress in that, is the involvement of professional arbitrators who are practitioners, areas of specialization, come with domain expertise, in addition to judges. I am not somebody who would be so critical of involvement of former judges in arbitration. In IP litigation, I think there are 1 or 2 developments that have contributed significantly to the changing landscape, particularly in Delhi. Some of you might be aware, but some of you may not be, that in the Delhi High Court some 2 years ago, the commercial division of Delhi High Court got what I often refer to as a subdivision, and it is the intellectual property division, where only IP cases are heard now. This development was coupled with a proactive trend of getting specialized judges to join the bench as judges, specialized IP practitioners to join the bench as judges, because a significant volume of commercial litigation in Delhi High Court is intellectual property related disputes. The 2 trends put together have created a very vibrant IP division, which in my personal experience matches up to the IP division of English courts in England, and I think that's a very, very impressive development. The second fallout of creation of an IP division in Delhi High Court is that not only is it more focused on IP work, not only are they trying to match up to the international benchmarks that they are aware of, the second most important outcome of creation of an IP division is that in Delhi High Courts there is an endeavor to make sure that trials now take place in court in high value commercial matters, something that had completely stopped over the last two decades. I was personally involved in a very high value patent trial that took place in court, with Opus coming from Singapore providing real-time transcription, and over a span of a few days the entire trial was over. Very interesting, my instructing lawyers told the judges that they had a parallel patent trial on some for one of the parties that they were representing in this arbitration, which had taken 8 years for recording evidence before a court commissioner. So that's, that is one extreme of how bad things were or can be because of our overloaded system. But this is a huge positive development in the Indian context in terms of how we do IP litigation in Delhi. I am given to understand, I'm not absolutely certain, but one of my juniors just told me when I was coming for this meeting today, that even the Madras High Court now has moved towards creating an IP division. So in terms of changing landscape in IP litigation, I think it is the focus that the commercial courts have now in creating specialized IP courts, and they take a lot of inspiration from the way IP litigation is conducted, adjudicated internationally, and they're trying to meet the international benchmark. I'm sure other colleagues will come and tell you their own significant observations about the changing landscape in arbitration, commercial litigation, and IP litigation in India. But I just thought that it would be a good way of opening the discussion by sharing sort of the pointers that I thought were of personally of great interest to me. Thank you very much.